May I be permitted to mention?
Yes.
I'm the petitioner in person. I filed a criminal appeal. It was admitted on the last proceedings. And the order was that the matter be listed on the next circuit for hearing. Since the matter is not listed super, so I am mentioning it for kindly list and hearing.
You have been convicted.
No, I am the petitioner of this.
You are the appellant convict.
No, no.
You are aggrieved with the acquittal.
No, I am the complainant in that case.
You are aggrieved with the acquittal. যার এগেনস্টে অভিযোগ জানিয়েছিলেন তাকে খালাস দিয়েছে।
It's not acquittal case. It was actually issues pertaining to revisional and appeal as well. Not actually actual because there was revisional issue and appeal issue as well. In the trial court proceedings, the trial court has rejected my application without appreciating the evidence and not taking.
All right, give it excessive.
Lordship, may I permit to mention a matter for extension of interim order, is a grant for inclusion in the list.
It has expired.
No, Lordship, it's
When it is going to expire?
Lordship, the date will expire on 23rd June, but the application which I filed for the extension is prior to that. So
Very
it's
good.
in-
Give the slip.
Lordship, grateful, Lordship.
Matter Lordship, criminal revision for extension of interim order.
Both the matters are
Both the
Criminal revision matter, Lordship.
hearing.
Here, no, it's a motion stage, Lordship.
Motion. Give.
Great, Lordship.
One criminal matter motions.
may I be permitted, madam?
For curriculum, my name was restriction.
In the judgment.
Right.
পড়ো তোমরা না।
This too is for.
Wait. ওটা তুমি মেনশন না দিয়ে দিন আগামীকালকে মিস্টেক হয়েছে বলছে লয়ারের নাম। What is your
RI.
RISHIN? Rishin.
This too is for
What has been typed? What has been typed wrongly?
RA instead of RI, it's RA.
And 180 days,
Very good.
one more rectification is required, 180, instead of 6 weeks, 180 days has been deployed. For satisfied hour,
180 days will be all right.
6 months.
Yes,
Initially 1 month was.
it is absolutely all right, sir. It was consciously passed.
This for correction of the cost type. My lords that passed an auto my lords. And instead of my lords, Dipti my lords, Dilip has been recorded in the auto my lords.
Two mention না দিয়ে দাও, correction.
My lords, one for extension of interim order. And one more is my lords, restoration.
One after
application.
another, sir, one after another.
One is
My
the
SO will
restoration
jumble up.
application.
Which one is restoration?
My lords, this. CRR.
CRR has been dismissed by default.
Yes, my lords.
By me?
No, my lords, the previous bench.
Say like that.
I'm right.
There are three ABCC equivalent matters, one for application, one is for hearing.
These are motor accident appeals. What is the nature of application, madam? নিয়ে নিন দিয়ে দেবেন। It has already expired, madam. When it has expired? What are you doing?
Grant of
So it is in the month of June, we are in the month of August. What are you doing now? Any application for extension has been filed? Formal application? Are you sure? দিয়েছেন গ্র্যান্ড নাম্বার দিয়েছেন? Give it. Same. Extension of interim order. Yes, call the list.
Number 1.
The total compensation amount is assessed to the tune of rupees 10,90,000. This court has passed the conscious order with regard to 180 working days within, not after, and it will carry interest. Naturally, you are not going to be absolutely. So long they will make delay, it will carry interest,
Absolutely.
which is why it has been consciously done. Kindly check your names also.
Lot.
Thank you. Call the next matter.
But this is the matter.
What is CRAN 2 or 25?
Yes, this is the state had taken out this Milord, this revisional application, the CRAN Milord, while granting the interim order at the very first day, while recording the impugned order Milord date, that has been mistakenly recorded. For a correction, that CRAN has been filed. The very initial date, that is the 3rd July 2025.
Impugned order was passed on 23rd February 2024.
No, that is recorded 23rd February.
By correcting the date of impugned order,
Is a
being
June,
order
Milord.
number
It will not
21st
become June.
instead of, oh,
Yes, Milord. Yes.
it should
Yes,
be
yes.
21st June 2025
Yes,
instead of 23rd February.
yes.
In the very first order.
A very first, 3rd July Lordship 2025 order. Perhaps in the CRAN I have annexed.
Very good, sir.
Lordship.
Give me a second, sir.
Good order is 21st June. In the prayer Lordship can see in my revision.
No, I am searching for the certificate.
Yes, Lordship, that I got understood. Lord.
It should be order number 5123, 24, 24.
Yes, Lord.
What have you got to say with regard to this, sir?
Wherein one application was prepared by this, but don't know whether any application was prepared, submission was made for correction of names of the
Correction of names.
names might be.
No. That was
The cost title, the name of Learned Advocate General, Additional Advocate General George Chaudhary be added as Learned Counsel appearing for the state. So the correction was made by the judge who has passed the order. Lordship. So my contention with respect to that, whether if any additional or alteration is required to be done in the order, this matter to be placed before the judge passing the first order. This is my contention.
First time I am hearing.
This is my contention because there is a notice. This is an order wherein recall or any modification is to be required to be taken by the.
কি দিচ্ছিস আমাকে দেখা কি এটা যে নিজের পড় তোরা পড়াশোনা করে আছিস কি
Ashun. CRAN 3.
Oh.
I'm sorry, CRAN 2 of 2025, no?
Yes, Lord.
CRAN 2 of 2025.
two, three, four respondent, opposite parties, they did not file the affidavit of opposition. One
See-
has only just now had served and filed.
Arising out of the self-same order.
Opposite party has directed to file a affidavit of opposition. They haven't filed.
দেখি কি ফাইলটা আছে
চলছে তো, ওটাই তো চলছে।
Not
Malad,
that, but two type.
item number 2 টাই এটা।
Two type বলছে। Oh, Malad lost guy. In item number 2, Malad, the order was that the respondent or opposite
Oh.
party shall use the affidavit of opposition.
He has filed.
No, no, only
No, only
one
one has filed.
Two, there are other respondents, opposite parties, 2, 3, 4. They did not, they haven't opted to file. That, Malad, I have brought to your
So
lordship.
where are they?
Malad, just I have brought to your lordship.
Not required. It is their headache.
Lordship.
Malad, 3 and 4, Malad, kindly, Malad, can both the matter taken up at 11:30, Malad, as because the case diary of item number 4, Malad. Case diary of item number 4 is yet to be received, Malad, on the way, Malad. No, these are kindly, Malad, 11:30.
You are opposing the prayer for extension.
Yes, Malad.
Very good. 3 and 4 pass
We want
over.
final hearing, Malad.
I shall see. এটা বন্ধ করতে বলুন না গাইলাম।
11:30, Malad.
What time will it be called?
11:30, Malad.
3 and 4, 11:30 p.m.
Grateful you.
Five.
I'm for the state, my lord. I'm holding the seat.
Your lordship, your
Let the file be placed first. CRAN 3 is the application for extension.
For extension, my lord.
What is the matter about?
It is about criminal breach of trust, cheating and forgery. The entire dispute was out of a civil dispute, your lordship. And a title suit is pending before the ACGM Shiliguri regarding this. All the petitioners are senior citizens, your lordship. Therefore, the petitioners need some time to collect some documents for the final hearing. Till then, we are praying for extension.
What more document you will file? What is the scope? Any liberty was given to file supplementary affidavit? Then? No time.
Lordship, I have already investigated the matter and his involvement is only.
Which order is under a challenge? It is for revision or quashing?
Washing. Washing away.
How in course of investigation you came to a finding that the alleged power of attorney is a fake one,
Lordships,
apart from the oral statement?
Lordship, some 161 statement is collected by the IO,
Huh.
and they have stated that during any point of time, they execute the power of attorney.
Who executed the power? The
Lordship,
allegation is that the Somnath Kundu executed the power of attorney.
yes, Lordships. In favor of the Amulya. And subsequently Amulya.
But what
died.
materials have been collected that Somnath Kundu never executed power of attorney? Show me the relevant portion.
Let's say I have folded the 161 collected by the IO, Lordship. The-
Where is the charge sheet?
Charge sheet not filed, your Lordships.
The investigation is still in process.
Process, Lordship. They got bail, Lordships, and thereafter they preferred this criminal revision, Lordships. But charge sheet not filed is primary stage of investigations, Lordships. And moreover,
Is it not too early?
yes, Lordship, main thing is
Is it not too early? No, they have made a requisition for obtaining the specimen signature of the Somnath Kundu from the bank.
back, Lordships. So at this stage, your Lordships, after charge sheet file, after getting the
They will make a comparison.
yes, Lordships. But initial is very initial stage.
Absolutely. Take down.
CD টা দিয়ে।
CDB return.
Lordship, in item number 6, I am appearing on behalf of the appellant petitioner led by Mr. Sheikh Abu Jafar. My lord, the service has not been completed in this matter.
Have you effected service?
My lord, we have delivered, but the service has not been completed. This is the report, my lord.
It is submitted on behalf of the petitioner.
Criminal division have referred against the order dated 21st March 2025, passed by the London Judicial Magistrate Third Court, Jalpaiguri.
21st March.
March 2025. Can you see, my lord? And my lord, can you see the subsequent order that is 19th April 2025? Without making any application under section 143A of the NI Act, the London Trial Court suo impose a order to pay 10,000 in default WA will be issued.
What is the check amount?
Check amount is 15 lakh. Now, my lord, can you see? On the order that is 4th April 2025. When I was enlarged on bail.
Check amount is 15 lakhs.
15 lakh. No application was filed under section 143A for interim compensation.
Filing up application is mandatory.
Madam, there is discretionary.
দেখি
Mandatory.
একটা দেখি ভাই বার করুন তো।
Madam, mandatory, madam.
Let me see. Negotiable instrument act.
And that act, that the provision is not mandatory, that is discretionary.
Then the learned trial court exercise discretion. What is the wrong?
Madam, application should be filed.
Notwithstanding anything contained in such and such, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant.
There should be an application.
Is it the mandate of the legislature that they are upon an application by the complainant?
Court suo motu cannot pass any order to impose condition. In that context, my lord, in a similar situation, and the Joyous Lordship kind attention on observation passed by the Honorable Court will bench. In a similar situation.
It was not indicated as an interim compensation.
No, my lord. There is no whisper in that order. Just the learned magistrate in charge observed that I am just reading the order. And
Take down.
I am for the.
I am for the state, my lord.
But we are seeking quashing of the proceedings on the ground of settlement. Lord, the joint plan application has been filed. This plan 1 of 25. Please. Thank you.
Then one, so.
What is the written complaint, sir?
Lord, at page 10 of my application. The main application, Lord, page 10 onwards.
What is this?
Lord, the CRAN has been filed. My learned brother has handed over a copy as well. This is the copy of the CRAN application.
Who has filed the CRAN?
Lord, we have filed it jointly, 2 affidavits. Paragraphs 4 onwards are in.
Sole accused.
Yes, Lord. First, he, Lord, executes the agreement. Then, after receiving the notices of arbitration, he retracts back from his position and files this complaint.
Which paragraph is relevant, sir?
Lord, 4 onwards. Paras 4, 5, 6, and 7.
They are present.
Yes, my learned brother is appearing for the complaint.
Your clients are present.
Clients are not present.
Who is Advocate Gopal Roy? You have identified your client. And who is Advocate Mayank Rai? You have also identified. Take down. CRAN 1 of 2025. This is a joint application. Not today only.
Let the interim order.
3 and
be
4?
extended. No, we filed an application for extension.
No, it has been tagged together. No, that is a
Yes.
difficulty. Ensure the availability of CD on tomorrow. Not today only. Call the next matter.
In item number 9, I am for the revision petition, my lord. Am I audible to you, my lord?
You are audible, not you are not properly visible. Only your forehead is visible. Adjust the camera, sir.
My lord, my lord. Is it okay, my lord?
Now it's okay.
Up to this level. I want to see who is moving before this.
I mean, now,
Yes. Fair enough.
my lord, the order infused is at page 17, my lord.
Page 17, sir.
17, annexure P3, my lord, by which the bailable warrant has been issued against the revision petitioner, my lord.
How you are agreed, sir?
My lord, kindly comes to page 21, 22, and 23, one by one, collectively, my lord. 21. Hello. Page 21 is an communication from telecom. It may be the authority of the court to the DCP outer district, whereby the summon attached were supposed to be served upon the accused petitioner, revisionist petitioner. It is dated on 21st April 2025. Timing is 10:28 p.m. Got it, my lord? Page 21.
You are a resident of which area?
My lord, I am the resident of Rajasthan.
You are Jitendra Singh.
Jitendra Singh, my lord.
You are requested to serve the same to Jitendra Singh. You are a resident of Delhi.
Delhi, properly Gurugram. My lord, kindly see page 22.
I am there only.
My lord, kindly see page 22.
Yes, I am there. Page number 22.
22. The summon was, the date was fixed on 23rd 4th 2025. The letter was served to the particular commissioner Delhi on 21st 4th 2025. Thereafter, on 22, this was served upon one of my family members. So how can I appear on 23rd from Delhi to Kuch Bihar? For that sole reason, I could not appear. That was the order speaks the non-SR. Whether I don't know whether the service report was complete or incomplete, my lord. My lord, I would request my lord to kindly have a look section 69 of BNSSF for once, which speaks the summons how to be served out of the local jurisdiction.
When it was served upon your family member, sir?
on
But these are-
22, on
these things are all
22/4,
irrelevant because
2025,
I'll-
one
I'll
day
just-
prior to the date of appearance, my lord.
22nd.
22nd. How could a person from Delhi attend the court in Kuch Bihar on 23rd when the summons was itself served on 22? On 21st, it was in communication between the department. Well, kindly have a look.
BNSS is in the, you're saying
69.
which one?
Section 69 of BNSS.
BNSS টা বার করুন। ভারতীয় ন্যায় সুরক্ষা সংহিতা। Section 29.
Section 69, my lord, 69. 69.
Yes.
My lord, it specifies the provision how a summons has to be served outside the local jurisdiction, outside the local limits of the court, which has not been complied with.
Yes.
The total 16.
So it was not through the magistrate.
My lord, it was not through the magistrate. It was through the local PS, that too upon one of the relatives through mobile.
So what is your prayer now?
My lord, the order impugned has to be set aside. I may be given a liberty to appear before the learned court in accordance with law, Your Honor. My lord.
Mr. Chakraborty.
Malad has gone to page number 16. Charge sheet was filed.
Hmm.
After filing of charge sheet, court issued a bailable warrant. They stated that therefore this court has no other authority but to issue bailable warrant in order to ensure the attendance of the accused Jitendra Singh. Now, after this was passed, this order was passed on 20th of May 2025. They preferred an application for anticipatory bail before the Honorable High Court. I was the other side, I was for the state malot. After going to considering the CD, the bail was rejected. Instead of surrendering before the trial court, they preferred an application, which is in page number 15 of the main application.
We have annexed all the documents.
They have preferred an application for anticipatory bail, and after that was rejected, without surrendering before the court, now they have challenged the order of revision. Whether this is maintainable, number one.
My lord, kindly have.
Again, the only option
Wait,
is
sir, wait.
the
My lord.
only option is before the apex court. If anticipatory bail is rejected, either you have to surrender or you have to meet. No revision lies. This is one thing, indirectly they are challenging the order of the anticipatory bail. If my lord grants the revision in their favor, then they will surrender and they will get the bail, or the order, if it is that they are with the order against whom they are aggrieved. If that order is not there, then it's okay, but their anticipatory bail has been rejected. The same set of lawyer who is appearing in this case, it's not that it was not within the knowledge of the lawyer that bailable warrant has been issued. They came before the honorable court and their bail application was rejected on merit after going to the CD. Now how my lord can consider this order?
Take down.
Well, at that relevant point of juncture, we were not aware of the fact, we have not obtained all the certified copy. When we obtain all the certified copy, we have mentioned in paragraph 5 and 6 of our present application, my lord. It is not a case that we have hide anything from this honorable court. We have mentioned in paragraph 5 and 6, my lord.
Listen to my order. The legality, propriety and correctness of the order dated 20/05/2025, 20/5/2025. As passed by the learned additional session judge, fast track, learned additional session judge, fast court, within bracket NDPS Kuch Bihar. In NDPS case number 81 of 2024 is the subject matter of the instant revisional application. Stop para. By the impugned order, learned trial court issued a billable warrant of rupees 1,000 against the present revisionist. Stop para. At the time of hearing, learned advocate appearing, নামটা দিয়ে দেবেন, learned advocate appearing on behalf of the revisionist accused at the very outset draws attention of this court to the to the certified copy of the order number 24 to the certified copy of the impugned order as passed by the learned trial court. আচ্ছা আমি ওখানে না মামলার নাম্বারটা আমি আর বললাম না। ওই সাবজেক্ট
NDPS case number 81.
বলেছি ও ভেরি গুড আচ্ছা at the time of hearing কি বললাম?
Learned advocate appearing on such on behalf of the defense acting at the very outset of attention of this court to the impugned order.
Certified copy of the impugned order.
The certified copy of the
Impugned order.
impugned order as passed by the learned trial court.
Full stop. আর কিছু বলিনি তো? Attention of this court is also drawn to page number 21, 22 and 23 of the instant revisional application. It is submitted it is submitted on behalf of the revisionist that on conjoint perusal of the said 3 pages, it would reveal that the present revisionist is a resident of Northwest Delhi, and the notice as has been sent by the learned trial court was served upon a family member of the petitioner only on 22/4/2025. Poster. At this juncture, learned advocate appearing on behalf of the revisionist draws attention of this court to pay section 69 of BNSS. It is submitted that section 69 BNSS mandates as to how service of summons is to be effected outside the local limits. That is by a magistrate within whose local jurisdiction the person summoned resides. It is submitted that the said notice was served not through the jurisdictional magistrate but through the Deputy Commissioner of Police, which is contrary to the provision of section 69 of BNSS. It is thus submitted that learned trial court, while passing the impugned order, has failed to visualize the true spirit of section 69 BNSS as well as the practical difficulty of the present revisionist in appearing before the learned trial court on the day when the impugned order was passed. Stop para. It is thus submitted. There is a fit case for setting aside the impugned order. Stop para. Such contention is, however, vehemently opposed by Mr. Chakraborty, learned advocate appearing on behalf of the respondent state. Drawing attention to page number 15 and 16 of the instant revisional application, being a copy of the order dated 1/7/2025 as passed in CRM within bracket A 388 of 2025 by coordinate bench of this court, it is submitted by Mr. Chakraborty that in connection with the NDPS case number 81 of 2024, the present revisionist has approached before this court for obtaining a favorable order of anticipatory bail. However, such prayer was turned down by the said coordinate bench on 1/7/2025. Stop. Paradik. It is thus submitted by Mr. Chakraborty that in view of the prayer, in view of rejection of the prayer for anticipatory bail, the present revisionist has got no other alternative but to surrender before the learned trial court. Stop. It is thus submitted by Mr. Chakraborty. Instead of doing the same, the present revisionist has challenged the impugned order with the sole purpose to delay the proceeding. Stop para. On careful perusal of the entire materials as placed before this court, and after hearing the learned advocates for the contending parties, it reveals to this court that that by an order dated 1/7/2025, as passed in CRM within bracket A388 of 2025, the present revisionist application under section 438 CRPC is now 482.
482, my lord.
482 CRPC BNSS. 482 CRPC BNSS has been rejected. Stop. Such being the position, as rightly pointed out by Mr. Chakraborty, the present revisionist has got no other alternative but to surrender before the learned trial court, unless such an order for rejection of anticipatory bail is assailed and stayed in the Honorable Supreme Court. Stop there. This court finds sufficient justification in the submission of Mr. Chakraborty, inasmuch as when the application for anticipatory bail was rejected, anticipatory bail of the present revisionist was rejected, the present revisionist had no other alternative but to surrender before the learned trial court.
The revisionist
Had no other alternative but to surrender before the learned trial court. In absence of any stay from the Honorable Supreme Court. From the Honorable Supreme Court. Stop para. In view of such, while disposing the instant revisional application, this court directs the present revisionist to appear before the learned trial court within 15 working days from today, failing which learned trial court shall issue non-bailable warrant of arrest against the present revisionist for his apprehension in connection with NDPS case number 81 of 2024. With the aforementioned observation, the instant criminal revision is disposed of.
My lord, one indulgence, my lord. If surrender, the bail petition may be disposed in accordance with law, my lord, without being prejudiced of this observation, my lord. My lord, what indulgence, my lord? If surrender before the my lord, am I audible?
From the back. Warrant of permission has been issued without complying section 67 and section 69 of the.
Which order is under challenge, sir?
And it's 5th of December 2020. And subsequently on 9th.
So I want to avail the privilege of anticipatory. The Lordship, can you set aside the order? I should be coming with an application for it. Nothing else.
Without waiting for the report, he has issued a WPA.
My.
It is under section in BNSS. No, proclamation is under section 84.
I'm seeing the order. There is no reflection of any presentation by the investigating officer or any application being moved by the public prosecutor that the proclamation should be issued. The court has issued.
So according to the court has to reach to an objective satisfaction that the person against whom warrant has been issued is absconding or is concealing. There is no such reflection in the order.
I will serve copy of the learned additional prosecutor, your lordship can dispose of the matter. I will be coming with an application in the section 430 of the CRS.
Ashwin. The subject matter of challenge What is the reason? Madam, what is the reason? I have not asked any question to Mr. Bhomik. Let Madam answer. Let her open the mouth. What's the reason, Madam? Mr. Bhomik is here. Please come. I am led by Mr. Bhomik, and Mr. Bhomik is not prepared today. This much. How long you are practicing? You are a student of? So am I. So if I be here, why not we will be there? Call the next matter.
Paying for washing of the issue. So Lordship can take the last portion of my application, your Lordship, is the imputed.
Yes, Mr. Bhomik.
But so far the case is concerned, my lord, the de facto complaint is my wife.
Hmm.
Now, my lord, can you see page number, my lord, 13.
Your anticipatory bail application is allowed.
In that case, in the case related to the page number 13, my prayer for anticipatory bail was allowed. And since long we are living apart. Just as I got the privilege of pre-arrest bail by the Honorable Court, she lost some frivolous allegation stated in the earlier that I misused some letterheads of the ball badminton.
You have been enlarged on anticipatory bail in connection with another PS case.
Another PS case. That is, my lord, page number 13.
It is Bhakti Nagar PS case number 716 of 2024.
My lord.
And it is?
My lord, it is now Oxynover police case, PS case number
992.
992 by 2020. As I got he lodged a complaint under section 150 clause 3, and I got the privilege of pre-arrest bail by the Honorable Court. Subsequently, just to harass me, this impugned FIR was lost. Because, my lord, since the initiation.
Have you filed any application for anticipatory bail?
No, my lord, this is available. Sections incorporated here are available. There is 336(2), forgery, punishment is 2 years, and non-cognizable. And so far section.
Take down. This is an application
But I'm for the petitioners. But proceedings under 498 and my lord 406. The petitioners are my lord the father-in-law and the mother-in-law. Now, my lord, earlier, the other in-laws had filed an application for quashing of this proceeding vis-a-vis them. And my lord, that order was passed, my lord, at page 30. My lord, this proceeding stands quashed as against the other in-laws. Page 30 onwards.
You are the parents-in-law.
Yes. Mother-in-law. Not very peculiar case. Kindly seize this order, then I'll.
Give me a second. Sir, will you please come to page number 34 and 35,
Yes, my lord.
paragraph 17.
Yes.
Kindly place.
Paragraph 17 and 18. That's
Kindly
the-
place, kindly place.
Yes, yes, my lord. I'm aware
You are
that-
bound by that.
that the
How can I
allegation-
take a contrary view?
No, my lord, I'm not asking for a contrary. I am saying that the situation under which this complaint was filed, I'm on that level. That has not been dealt with in this order. This order says that the allegations are against the husband, father-in-law, and the mother-in-law. But these allegations have to be tested on their own merit. It only says that the allegations are against the parents and the husband. But I am on the fact that these allegations have to be tested on their merit and the background in which they were. I'm on that level. Number kindly sees the background of this dispute. In the year 2019, the husband and the wife, they get married on 14th of March 2019. Now, my lord, right after the marriage, the torture upon the husband initiates. Ultimately, my lord, in the month of January 2023, the husband files a complaint. The husband files a complaint, my lord, at page 20. I'm sorry, my lord, page 29. Page 29 is the complaint, my lord, kindly reads it. It narrates the entire incidents, all the incidents that have happened in the house as well as in the house of the my lord wife, at the parental house of the wife. The husband lodges this complaint in the month of January 23.
This can be taken care by the learned trial court, sir.
Lord, this is one. This is one. Subsequently, my lord, in the month of March 2023, the husband files a suit for dissolution of the marriage on the grounds mentioned there. I am of the specific view, I am of the specific opinion that this entire complaint was filed right after the notice was issued to the wife. This was a counterblast to the allegations made by the husband and the in-laws against the wife. I am supported by a judgment of the Honorable Supreme Court
In-laws?
against the wife. The husband lodges this complaint. Then the husband files a suit
For dissolution of marriage.
of the marriage. She gets
Thereafter, the written
Yes.
complaint was filed.
2 months after the dissolution of marriage, she gets the notice. She files the complaint.
Sir, can it be said that those are the valid grounds for quashing?
Yes, my lord.
How do you establish that at least prima facie or on perusal of the written complaint
Yes.
or on the basis of the materials collected in course of investigation that the allegations are unfounded
My lord, I'm
or
supported
it is
just-
baseless or those observations are to be of such a nature that prima facie.
Yes.
Those are
Lord-
prima facie in nature.
Can I just please, my lord, we are dealing with a matrimonial dispute. This is not a general crime committed of robbery, of my lord cheating, of misappropriation. We are dealing essentially with
Let me see the, see the, sir.
Yes, ma'am. I'll just place a Supreme Court judgment, my lord, in a.
Very good, sir. I will look to that, but prior to that, I will, please allow me to look to this
Yes.
3D. Direct allegations are there, sir.
My lord,
Direct allegations are there.
my lord,
Charge sheet has been submitted.
yes, charge sheet has been submitted. Kindly peruse the judgment once.
There are several statements.
Note paragraphs 21 and 22. Para 21, my lord, at page 7.
Page number?
Page 7.
Yes.
Now it says, given the facts of this case and in view of the timing and context of the FIR, we find that the respondent number 2 left the matrimonial house on 3rd of October 2021. In my case, my lord, she left the matrimonial house in the month of October 2022. After quarreling with the appellant number 1 with respect to her interaction with third person in their marriage. Later, she came back to her matrimonial house, assuring to have a cordial relationship with the appellant number 1. However, she again left the matrimonial house. When the appellant number 1 issued a legal notice seeking divorce on 13/12/2021, the present FIR came to be lodged on 1/2/2022 by the respondent number 2. Therefore, we are of the opinion that the FIR filed by the respondent is not a genuine complaint, rather it is a retaliatory measure intended to settle scores with the appellant number 1 and his family members. Para 22, my lord. Learned counsel for the respondent number 1 state contended that a prima facie case was made out against the appellants for harassing respondent number 1 and demanding dowry from her. However, we observe that the allegations made by the respondent number 2 in the FIR seem to be motivated by a desire for retribution rather than a legitimate grievance. Further, the allegations attributed against the appellants herein are vague and omnibus. Similar to my situation. She makes a vague and omnibus allegations against all the family members of the husband as well as
No, allegations are not there.
kindly seize the kindly seize the complaint. The complaint is the basis of this entire proceeding. The complaint only makes an allegation of demand of dowry by the husband, father-in-law, mother-in-law, supported by the mother-in-law. The timing, the context of the FIR is also important. She left the matrimonial house in the month of October 22. She did not do anything for this entire period of 8 months. Only after she receives the notice of the matrimonial suit, she lodges this complaint. And Milord will also see that the witnesses in the charge sheet mentioned in the charge sheet are all interested witnesses, all members of the family. So, Milord, their version of the story has to be taken with a pinch of salt because they would obviously support the wife.
Have you annexed the,
That it.
no, have you annexed the paper relating to your
Matrimonial. suit.
matrimonial
Yes.
suit? What is there? Is
Is
that?
that page 17 onwards? Page 18 is the first order passed. Page 19 onwards is the petition.
Have you served up on the opposite party number 2?
No, my lord, just this. We are at the motion stage. I'll serve. Whereas 28 and 29 of the judgment is also in. Kindly
Mr. Ghosh, you please take back the judgment.
Lordship, Lordship, the petitioner number 1 is a private limited company and the petitioner number 2 and 3 are the directors of the petitioner number 1 company. Lordship, kindly takes up page number 23, that is the written complaint. Para number 3, that is on page number 25. Lordship, we and the respondents have been in the business dealings for a very long period of time. The business dealing in respect of the purchase of garden hardware materials. Lordship, it is all the admitted facts that we have been making part payments and regular payments to the respondent company since a very long period of time. Coming to the page number 26, Lordship. The complaint, para number 8, may I, Lordship?
Give me a second.
That the complainant company being induced by assurances and promises made by the accused person supplied products from its establishment, garden stores and chemical, that is the respondent, total amounting to rupees 29,40,357 on several occasions. Thereafter, we have made the part payments to them, and it is admitted by the respondent in par number 10 that the last payment was made by us on 25th of February 2021. In Lordship, this date is very important for an amount of rupees 1 lakh. That is in par number 11.
So why are not paying their money?
Lordship kindly takes up for that reason. Finally comes to page number 31, that is annexure A2. Lordship, this is the certificate of transactions we have obtained from Punjab National Bank that we have made in the name of the beneficiaries. Lordship, after this complaint that was filed by the respondent was on 1st August 2023, whereas these payments which we have made to the respondents, that is post after the filing of the complaint, Lordship. Is it on 9/11/2023? 17 August 2023, 31 August 2023, 10th of August 2023, and 13th of September 23. Lordship, annexure A3, that is page number 32. We have conveyed all the transactions that we have made in post after filing of the written complaint. For filing of the complaint, we have conveyed the same to the respondent. We have intimated them that we have made.
They said 11 lakhs an order due.
Yes, Lordship, that is the thing that they have in the complaint they have said 11 lakhs. but
70,
After
1 lakh, 1 lakh 30, 1 lakh
1,55,000.
55,000.
Yes, Lordship, we have made it after the complaint was filed, and thereafter the
So clear all the dues.
Lordship kindly comes to page number 35, A4. Annexure A4, that is when the complainant was examined under section 200 and thereafter police was asked to file a report in the respect of same. The police has filed the report, but the report is nothing but just the reiteration of the complaint, Lordship. Here the amount that have been stated is same as which have been stated earlier in the complaint, that is 11,61,571. There is nowhere stated that we have made further payments to the complainant, Lordship.
Take down.
Item number 15. As read for watching of the proceedings being NGPPS case number 508 of 2025. The FIR is in page number 32 of my application. For the sections will be 406 and 420.
This really creates some difficulty for someone.
406.
Magistrate, both are magistrate travel, no? But both are non-bailable.
Both are non-verbal. Basically, the allegation out here is that I have taken one.
I'm sorry, what is the FIR?
FIR is in page number 33, written complaint, and formal is 32.
Give me a second.
32. It's a one-page FIR. United cases slowly.
Yes.
So what here is there? For the amount was 1 lakh was taken by the petitioner. Well, the allegation is that 60,000 has been limited by way of a check, which has bounced, which has dishonored, and subsequently a case was filed before the in the jurisdiction of Siliguri. Now this FIR is for 40,000 rupees, which is in the district of Jalpaiguri, NPP. My contentions are two, Lordship, in this matter. One, NIT case is already pending for rupees section. With the FIR at this stage, we cannot say that any agreement as such has been arranged with the FIR. During investigation, it might come. Now the case is that it arises out of a contractual liability. In between that allegation is that make advance payment of rupees for making him the lawful owner of a wine shop. That is the allegation. So, Lordship, in this matter, Lordship, 406 and 420 have been clubbed together. Your Lordship knows better than us in this matter that 406 and 420 cannot be clubbed together. There cannot be cause of actions for 406 and 420. For this, Lordship, I have annexed judgment of our.
No, I understood.
Lordship.
Breach of trust and cheating cannot be clubbed together.
Cannot come.
Why there will be quashing, sir? It discloses a prima facie cognizable offense.
No, Lordship. The issue is that, Lordship, there are 2-3 things. One.
No, sir, kindly look.
Yes, Lordship.
Subsequently said Devajit Datta has failed to crack the deal. And I asked to return the bag,
Lordship.
such and such. And from the very beginning, the Devajit Datta has dishonest interest to cheat me. And he had also given me false assurance to me that he will definitely return the amount to what is 1 lakh to me. So 420 is attracted.
No, Lordship, I'm saying I'm not different, no, Lordship. The case arises out of a contractual liability.
No, that is not disclosed. That is not disclosed, sir.
Lordship, this is
In the FIR, it is not disclosed, sir.
Although from the very beginning, Devjit Datta had dishonest intention to cheat me, and he had also false assurances that he will definitely return the amount. Why will he return, Lordship? If he has taken it in lieu of something, why will he return, Lordship? Now, Lordship, let me place my case, Lordship, with respect to.
What more you will place, sir? It discloses a prima facie offense.
I will, Lordship.
বুঝতে
Now, Lordship,
ultimately reject হবে, কিছু করার
if we, Lordship, if we go through the judgments, Lordship, it is in page para number 40, Lordship, sorry, page number 39, Lordship. Page number 39.
It's not a good case, sir.
Lordship, I will apprise this court.
Very good.
It is passed by the coordinate bench, Lordship. Page number 39. I annexed the judgment, Lordship. From 1, 2, 3, 4, 5, 6, 7, 8, 9, ninth line, Lordship. It has been reiterated in several judgments by the apex court that the same act or transaction cannot result in an offense of cheating and criminal breach of trust simultaneously.
Sir, it is a very initial stage. Very initial stage.
Lordship, 406 and 420 cannot go side by side, Lordship.
Very good. One will stand, one other will go.
Lordship, other thing, Lordship. I'm coming, Lordship. Lordship, page 40, Lordship. Page 40, last paragraph. In the present case, past commercial transaction between the complainant and the accused person is admitted since 2021.
No, there is no commercial transaction here.
No,
Take
Lordship,
down. No, sir.
now, Lordship,
I will not allow you.
Lordship, let me place two judgments.
I've heard.
Supreme Court, Lordship.
No, sorry. This is an application under section 528 of the একটা লাইন জাস্ট অ্যাড করে দেবেন তো, it further appears to this court that the allegations also constitute cognizable offense. Just এই লাইনটা অ্যাড করে দেবেন. It is item number? File please. Fileটা দিন.
But adding in the order date of 6th of November 2024, warrant of arrest has been issued by the learned decision in the Calcutta. But I come before your lordship, my lord, this petitioner earlier on bail and my lord, this is February 2024.
What is the date of the impugned order, sir?
But 6th of November 2024, page 21.
You were on bail.
Earlier I am on bail, what?
So what prevented you to attend the court on the next day?
Charge sheet was submitted on 16th of March 2023, my lord.
So you have been taken into custody. Huh?
I surrender, my lord, thereafter, my lord, I not place the, my lord, application. On last order.
Surrender of the accused not accepted. What does it mean? Surrender was not accepted.
When we surrender and if the court is not willing to have the, my lord, may I not press the application?
Take back the.
This is a benefit granted to
The lawyers. You can it to the lawyer.
Unheard of.
Otherwise, the plans.
কি বলবো না? What are the allegations against you?
But allegation is, my lord,
376, 448.
can you see the order? There is a love affair between the parties.
দেখে কি হবে? The legality, propriety and correctness of the order dated Only not today, not today.
I'm for the state lordship.
Yes, madam.
Where the 3.5 560 kg ganga was recovered from the two of his person, but I am for the Pradeep Modak, one of his person also. From his possession, 1.490 kg ganga was recovered. But he was, as it is the intermediate quantity, he was granted bail on 22nd April 2024. Whereas Lordship, due to some miscommunication and the fault of the junior advocate, non-maintenability of the daddy, he failed to present before the court for two occasions. That is all. So that Lordship, on to 12th February 2025, warrant of arrest was issued against the
12,
12th February 2025. Warrant was issued against the this.
12th February 2025.
It's the next of it. The name of the petition also. Judges was not intentionally Lordship apparently
How long you remained absent?
5 days. Lordship kindly.
Where is your bail order?
Not annexed. From 12, not even mentioned in the petition that he was on bail. Anyways, from order dated 12 February, Lordship will find the fix for appearance and supply of copy. We can presume that he was on bail.
From 12th February, and you are again apprehended on
29/7, kindly see his Lordship.
to remain in custody, sir.
29/7.
There is no lower court in our country.
Or Lordship.
No lower court.
Lordship says order dated 29/7. And the main thing which hurts me is that the learned trial judge has mentioned that surety was also given direction to produce, though that said order was not being has not been annexed. But in spite of the same, he did not turn up, and as such, warrant was issued, and subsequently he was taken in custody. Now, what is the illegality and property of the order?
No
I ask the
illegality.
question to myself.
Absolutely, no illegality.
And without paying bail, she now wants to quashment of the orders.
You pray for bail.
There is no illegality, Lordship.
Not intentional.
In revisional application, I will grant you bail. Unheard of. Mr. Ganguly?
Lordship. How can this order be quashed? There is no illegality in the same. So how can it be quashed?
Prepare an appeal before the coordinator.
That is the thing. She has to go before
At the time of hearing.
Not press now. We are.
Whatever
Hearing on behalf of the petitioner.
Hmm.
The instance division is filed challenging the order to get 77,025. Passed by the government judicial magistrate for the expeditions filed this. More than 5 years has already taken place. But till now, the movie is very under section 23 of the Protection of Domestic Violence Act. Series of activities from legal have taken. Several lawyers are. Ultimately, the petitioner is not able to exercise a petition acquisition. Which is not empowering her to, as she has already been thrown out of the share household, she has not been in a position to go back to the share. More than 5 years ago. That's already. 23 hearing has not been done. The file is ready.
Court number 3.
4.
Hearing of the main case or interlocutory application for protection order.
Shelter,
For the shared household.
share house.
So that she can
Section
be clear that the shared household.
Where is your application? In the DV Act, separate applications are to be made.
Yes, under section 23. The section 23 which I have annexed.
No, 23 is the main application or the interlocutory application?
Page number 11. 12.
Yes, 2-year application.
And section 23 is the interim.
That has also not been disposed of.
That is not.
You have paid for any monetary relief
I have paid for.
in the form of maintenance.
For maintenance, compensation as well as at this stage, residence one.
Wow, take down.
Actually, may I appear state?
Yes, sir. This Yes, sir.
Suit was filed in the year 2008.
Yes.
Summons was served, appeared on 2nd December 2008. And turn to order number 14, page number 29.
You are for the plaintiff.
It's a seal, page 29 minus 40.
Yes, sir.
Order number 14, dated 2nd December 2008. Second paragraph, third paragraph. Defendant number 1 to 8, place for time to file the written statement. Leave is granted as stated such and such. I got it. Now I can turn to
Please for time, such and such, objection, heard plaintiff, defendant number 2 is hereby accepted.
yes,
Those are 4 to 8, 4 to 8.
4 to 8.
Present petitioner filed by the author is hereby rejected. So date was fixed for framing of issue. Very good.
And turn to page order in view.
Give me a second.
Yes, sir.
Yes.
The petition was filed on 27/4/2023 by given number 6. After 15 years. And what is the reason assigned? Page 30. Allow that as the defendant has done something serious work, he is willing to contest, that is why page 30, my lord, this is the expression given. If it is
No, this is with regard to repairing.
no,
What about the written statement?
last portion of the order.
Which portion, Mr.
Yes.
Roy?
Second page, second paragraph. For the interest of justice.
Vacated and the delay in cause author is called the same is accepted.
Yes.
Here,
Yes.
for the interest of justice and proper activity, the defendant number 6 is allowed to contest. The expiry order so against the defendant is hereby vacated with cost of rupees 2000 payable by her by the plaintiffs on the next date. Delay caused in filing WS by the defendant is condoned and the same is accepted.
Also, this time consider page 30.
Page number
30.
30.
Explanation. 15 years explanation. That too after amendment of the code of rules or entry rules. Now I got it. Page 30 and SMT. If it comments to your lordship, and if it appeals to your lordship that this is a sufficient for 15 years condemnation, despite your receiving a summons.
তুমি কখন ক্ষেপ মারতে এসছো?
And at that material time, what was the stage of the suit?
And when prosecution is going on, PW completed, DW one completed at that point of time. What I rule one, I could understand what has the power to condone the delay. If this is the condemnation of delay 15 years, my lord, then there is the entire intention of legislature will first.
Mr. Roy, what from will get this stage?
Stage, my lord, your lordship file,
Stage means stage of the suit, sir.
present or that for
At that material time.
time. Latest or last one, year now, year आगे और तेईस आगे, लक्षण चाहिए
Very good, Ashwin.
Let me solve because
Very good. The subject matter of the instant revision
The petitioner and letter is a part. I'm waiting for not the my son, can reach the matter on sometime in this week, Thursday or Wednesday.
As per prayer made on behalf of the petitioner, let the matter be listed on August 20, 2025 under the same heading as a last chance.
My lord, I am appearing for the petitioner in item number 56, my lords. My lord, am I audible, my lord?
Yes, audible, sir.
Yes. My lord, the petitioner's marriage with the opposite party was solemnized in the year 1997. Thereafter, my lord, the opposite party left the residence and association of the petitioner far back in the year 2000. After 24 years of separation, my lord, the petitioner before your lordship brought an action for dissolution of his marriage with the opposite party on grounds of cruelty and desertion. In that matrimonial suit, your lordship will find that page 9 of my application, the matrimonial suit.
There is the amended plaint.
Yes, amended plaint. Thereafter, it was amended, and this is the finally amended plaint. In the pending matrimonial proceedings, my lord, the opposite party took out an application under section 24 of the Hindu Marriage Act for maintenance pendente light. Your lordship will find that in page my lord, 15. Which was
15.
registered as misjudicial.
15.
Yes, my lord. 15. Annexure A2.
Yes.
Yes, my lord. Thereafter, at page 35, your lordship will find the affidavit in chief of the opposite party. Thereafter, she was cross-examined.
In the miss case.
In the miss case, my lord.
Miss case under section 24 of the Hindu Marriage Act.
24 of the Hindu Marriage Act, my lord.
Very good. Then,
my lord, the petitioner was also, he tendered his examination in chief. Your lordship will find at page 39.
Yes.
And thereafter, my lord, he was cross-examined. His examination at page 41.
Very good. Then what
Yes,
happened?
my lord. During his examination in chief, my lord, your lordship may kindly turns to page 42 and 43. He tendered his placing. My lord, he is an Group D staff, a peon employed under ABN Seal College at Kuch Bihar. He tenders his pay slip dated, first one is at page 42, dated 15/7/2024, and the second one is at page 43, dated 18th March 2025. The lordship will find that his gross pay is 35,024 rupees.
Affidavit of assets and liabilities have been filed.
Tendered, my lord.
Very good. Then what happened?
My
Why
lord,
you are agreed, sir?
Yes, my lord. The learned trial court, my lord, passed the order impugned, directing me to pay a sum of 5,000 towards litigation cost and a sum of 15,000 monthly towards maintenance pendente light. Well, that will be half of my salary, my lord. My lord, it is settled proposition, my lord. There are no issues, my lord, from this matrimonial, this conjugal relationship, my lord. The settled proposition, my lord, says that ordinarily it has to be 1/5 of my salary, gross pay. Or otherwise, my lord, it can be up to 1/3, my lord. But, my lord, the learned trial.
Whoever will get this formula.
My
A
lord,
wife has a right to lead life equal to the standard of.
Yes, my lord.
standard
Definitely.
of
I bow down,
a-
my lord. I bow down, my
Yeah.
lord. My lord, but kindly
One half,
appreciate.
1/3, 1/5, whoever will get this formula. Your gross pay is 35,000 and not
24. 35,000 and 24 rupees. My lord, I am having a
Your-
loan, my lord.
Your
I have
statutory deductions are 150 plus 10, 160 rupees.
Yes, ma'am.
You deduct rupees 20,000 per month to your GPA.
Yes, ma'am.
So your net salary comes to 14,000 and odd.
Yes, my lord. Kindly appreciate, my lord. My net salary is 14,000, my lord. I have been asked, I have been directed to pay to
No,
my wife.
you deposit 5,000 in your GPA and pay 15,000 to your wife. Absolutely not. What is it wrong?
My lord, kindly appreciate, my lord. Kindly takes up page 30, my lord. My lord, I availed a loan facility for my treatment purpose amounting to rupees 1,56,000.
Huh.
Towards which, my lord, I am paying at about 3,500 per month for repayment of that loan facility.
Absolutely not. No, there is nothing to be interfered with. Ashun. The subject matter of instant revision application is the order number 15 dated 30/04/2025. No orders to cost.
Obliged, my lord.
Next,
I was 57, I'm praying for a short pass of them first. Mr. Master, will not say if anything.
next, pass over.
Now for the petition. But in this case, I have challenged the order for another additional passenger first accord Siliguri. I order number 6, it is 1/8/2025. Very simple.
Order dated?
Order then 1st August 2025. Order number 6. 35 crore.
Give me a second. What was the misappeal for?
Actually, madam, if you not see the page number 27. After hearing from the both sides, Planet Child Judge was pleased to pass an order of temporary injunction.
You are the plaintiff.
Now, my lord, I got the temporary injunction and appeal was.
That was challenged before the appellate court.
Appeal court without assigning any reason. And you see the order, madam, I'm very sorry to say, without assigning any reason. So the appeal was admitted earlier. At that time, there was no stay. Without assigning any reason, just the trial court says, considering the submission, so there are good that inquiry will be stayed till next date. As if the stay is not allowed, the appeal will be.
Have you entered appearance before the appellate court?
No, no, someone on this. Date was fixed for 1st September for service. Without assigning any reason, my lord, this order has to stay. Because, my lord, the order was, the appeal was admitted by the additional session district judge Siliguri as first. Then they did not move any stay.
I'm directing the appellate court to dispose of the appeal within a specified time.
In the meantime, the stay may be stayed. If that order has not been stayed, the order is unreasoned order. I am very subject to the lordship correction. Without assigning any reason, unreasoned order. There is no reason has been described by the session judge regarding the course of order of stay. Only one line, if the stay is not be allowed, the appeal will be infractuous. That's what we asked the one. My humble submission, the appeal may, my division may be admitted and the order implement to be stayed for a limited period. In the meantime, I will direct to appeal before the appellate forum.
The subject matter of the instant revisional application is the order
My application, Milord. Before I take up, Milord, this application for recall. But for 1 minute, let me explain the chronologically what happened, Milord. Then, Milord, I will pick up your lordship's order. Milord, the marriage took place in 2013. Husband, I being the husband, suit filed in 2014. Ground of 12. Then, Milord, as it could not be delivered, the summons, paper publication was also made in terms of the court's order. Paper publication on 5th July 2015. Thereafter, also, despite such, she did not appear, the suit was declared ex parte in 2015. Milord. Then, Milord, Order 9, Rule 13 was allowed. Vacating of such Milord ex parte, that is in 2022. In the meantime, I being the husband, Milord, I got a second degree. I have a child. Now, Milord, against the order of that, Milord, 2022, I preferred this instant revisional application. That is in 11.
Order 9, Rule 13.
Yes, Milord. Order 9, Rule 13 was allowed, Milord, on 24/11/2022.
Challenging that order, you have preferred the revisional application.
Yes, Milord. In 23, I have this revisional application.
Which was disposed of in your absence on merit.
On merit, Milord, kindly now come to the your lordship's order.
How can I entertain this? I cannot understand.
Milord,
Go before the Supreme Court.
No, Milord, kindly see, Milord, the order of your lordship, which, Milord, at page 30, Milord, 30. Milord, I prefer the revisional application. At best, Milord, it can be asked for the revisional application, maybe dismiss. I understand that the Milord, the CEO or the theater generally disposed of on merit. But Milord, paragraph 3 that none appear, Milord. It is mentioned. Then, Milord,
This court exercises power of superintendence and pass an order on merit.
Milord,
এই এর কনস্টিটিউশনটা দেখি বাবা, এই তো আছে। Give me a second. Yes, Mr. Chaudhary.
Milord.
How can I recall this order? Probably I cannot. Are you fortified with any judgment?
Milord, yes.
Show me some precedent.
Yes.
Have you served?
Milord, I have. Execution. Milord, it has been served to email.
Is that the correct email address?
Milord, that which was given, Milord, to the lawyer appeared on behalf of the Milord, the opposite party. Milord, straight to Milord, kindly come, Milord, the page, internal page, 14. Sorry, paragraph 14, I'm sorry. Milord, which is a quote unquote portion that is in Milord in the other proceedings, Milord, in Indian Bank versus Sottam Fibers India Limited. Milord, for unquote portion from the 3 lines, Milord. last line. Similarly, lawsuit got it. Similarly, where the court is misled by a party or the court itself commits a mistake which prejudices a party, the court has the inherent power to recall its order. But why misled? But now your lawsuit can see.
Anybody misled me or I have committed a mistake?
Second one, na? This paragraph A, but even which your lordship has reflected in your lordship's order, paragraph A, that certain such documents and all deliberately furnish the wrong address. But just in 1 month before, in a section, in a application of 24, na? Sorry, missed this, 24, 125. In an application before the Milad by 125, the same address where I have data been delivered.
Then why have not had serve notice there?
Milad, we have some.
Service করতে হবে না. You have to come before the principal bench then. Or
Milad, my lordship kindly understand our difficulties. We have tried there. Milad, kindly see, let it be Milad adjudicated. Milad, I have a definitely.
no, yeah. So notice is to be served, no? Ashun,
Milad, if your lordship can do one thing, Milad, kindly recall the order, then Milad, let it be restored back in its original position. Then Milad, definitely they will have a right of.
It cannot be done. Your other side also have a right of
Then
audience.
Milad, kindly keep it on Thursday. I will, because
They will be very difficult.
Milad,
It
lordship,
will be at the end of the circuit.
Milad, appreciate the difficulty.
I will take up your matter.
Being a circuit.
I assure that I will take up the matter in the principal bench. উকিল বাবুরা আছেন না এখন কেমন মুশকিলে পড়েছে Can 2 of 2025. This is an application for recalling of the order dated 3/1 6-2 is appearing. Mr. Vikramaditya Ghosh, where is he? He was there, I find him. That is not completed. Ashun. Mr. Ved Rai, learned advocate appearing on behalf of the petitioner submits before this court. The service upon the opposite parties is yet to be completed.
Sixty-one, I acted on behalf of the petitioner, this matter was heard, lordship, this is, I have now against the order whereby my application under order 607 was rejected. Your lordship heard the matter, have directed me to serve copy to all the opposite parties. Lordship, there are 12 opposite parties. Lordship knows the postal disturbance is.
Service is not affected.
So, I only 5 I took, but it could be done, but another 10, but.
ওই সেম অর্ডার MS শ্রেয়ানবিস নামটা চেঞ্জ হয়ে যাবে আর বাকিটা সেম অর্ডার হয়ে যাবে নেক্সট সার্কিট
Stays there till September end.
no prejudice is going to be caused.
Yes, then I'll get another side.
Call the next matter. Who's for the petitioner? You are for the petitioner, but you are standing in the wrong side.
Change wrong side.
From this side.
Those boards are yellow.
Those boards were not never there.
Yeah.
It was never there.
My lord can understand after hearing the matter who is petitioner.
What is can one for?
Can what's the bill number? Oh, extension of bill. My lord is hearing the main matter, so can you keep it?
You are for the petitioner.
I am for the petitioner. My lord, defendant number 38 to 42 is the petitioner before my.
Give me a
In a
second.
suit for declaration, and under friend is opposing me. He is for the plaintiff opposite party. Before going to the improver, kindly give me 5 minutes time. It will be easier for us. But kindly come to the plain. That is at page 14 it starts.
Plaint.
Plain.
Page number?
Page number 14, 1-4. This is for declaration. Kindly come to, in the plate, kindly come to paragraph 11 at page 18. Statements kindly allow me to read.
একটু আমাকে না ফ্ল্যাগ গুলো খুলে দিন তো ভাই paragraph 18.
Paragraph, page 18, paragraph 11.
Yes.
May I read it to us?
Yes, sir.
That in the meantime, on 2nd September 2022, the plaintiff learned that the defendant number 1 to 37 have executed 5 deeds of sale in favor of the defendant number 32, 8 to 42, my client. Being number such and such, all registered as office of the ADSR at Bhaktinal. Thereafter, the plaintiff intended to obtain certified copies of the alleged deeds, but due to lack of money, the poor plaintiff failed to obtain the same, and instead the plaintiff obtained computerized copy of the deed information for those alleged 4 deeds. So this is Malab, the deeds in my favor has been impugned. Kindly come to the prayer. Next page. Decree for declaration that the deeds which is in subject matter of paragraph 11 are void and not binding upon the plaintiff or his other co-owners. B. A decree for recovery of first possession of the suit land after ejectment the defendant from the suit property and by way of disbanding the boundary wall along with small pakka corrugated tin shade structure such as such and such, and the decree for permanent injunction. As well as got it.
Is it the case of the plaintiff that by virtue of those deeds they have came into possession of the suit property?
This is our case, that by virtue of this deed, as paragraph
Yeah,
11.
I'm sorry, defendants came into the possession.
That is the case. So, my lord, from here it can be ascertained that requires a scrutiny to value the suit.
Is he a party to the deed?
Who?
The plaintiff?
Plaintiff is not the party, but the relief paid for the cunning drafting, my lord Chief Justice Krishna says. By cunning drafting, he is trying to avoid the declaration which has been paid for eviction is clouding my title. Can you see the prayer A? Deed is void. Deeds are void, by which I obtain the title at paragraph 11. So he is clouding my title by prayer A. Am I clear to mind? Only the prayers has to be considered in consonance with paragraph 11.
Very good.
Our submission is that by virtue of this prayer A, it's required a scrutiny to be made whether the deeds which has by which we have in possession and the title is to be declared void. Otherwise, his eviction decree cannot be passed. So it is a consequential. Now, my lord, kindly come to the
So according to it, the suit is undervalued.
I have filed two applications, Order 7 Rule 10 and Order 7 Rule 11. Order 7 Rule 11 cannot be touched now because if today's Order 7 Rule 10 is allowed and it is placed before any other court in the
Mr.
jurisdictional
Basu,
court,
the law is well settled that if he is not a party to the suit and he intends to avoid the same, he is not bound to pay the. It's a
No,
simply
why I am saying-
why will pay the market advance fee of the on the market value?
Kindly see
It's
the
a settled
language.
question.
Kindly see the language. Kindly come to
Had it been a case of a cancellation of deed, I could have understand.
My lord, I am submitting, my lord. Kindly, if I am wrong, my lord, kindly repeating, my lord. Kindly pardon for repeating. I say here an inquiry is necessary. Kindly come to 7, Roman 7, section 7, Roman 7A. That was sorry, got it.
Section 7, Roman.
Roman 7A. Roman 6.
Roman
sorry.
6, say like that.
Section 7, Roman 6A.
Huh.
A trespasser where no declaration of title or property is either paid or necessary for disposal of the suit, according to the amount in which the relief sought for is valid. If this inquiry is not necessary, then my lord 7 A will apply.
A trespasser where no declaration of
He
title
has paid for
to property is either paid for or necessary for disposal.
or I am on or necessary for disposal of the suit.
According to the amount at which a trespasser
This-
and no
this much I
declaration, but here declaration has been sought for.
This much I can, my lord, I know, my lord, a party who is not the party, he cannot, I cannot compel him. But kindly consider, this is the only point before my lord. Whether for declaring his suit for recovery of khas possession, a owner can get the khas possession. I am the owner by virtue of the deed. This deed required to be adjudicated whether I am entitled to have my title by virtue of those deed also. Because I am party to this proceeding. Then whether, my lord, kindly consider whether 6A inquiry is necessary or not.
So it is according to the amount at which the relief sought for is valued
No.
in the plain subject to the provision of section 11.
No, that's why an inquiry is necessary. The court refused to inquire. The order impugned, court says no inquiry is necessary. as which my lord was just at the outset of submitting, that it is law is settled. Law is settled, but if it is necessary for giving the relief to the plaintiff, it necessary for disposal of the suit, this inquiry, whether the inquiry will be held or not. This is the precise question before my lord.
No, Mr. Basu, why this clause is important? For recovery of possession in a suit for recovery of possession of immovable property from a trespasser, where no declaration of title to property is either paid for or necessary for disposal of the suit, according to the amount
Then
at which
exception.
report.
Then this is exception. If an inquiry is necessary, then my lord, exception will not come. May I read for your lordship once again? According to my humble reading, a trespasser, he has said he is a trespasser, where no declaration of title of property is either paid, he has not paid, for or necessary for disposal of the suit. If the court finds that it is necessary for disposal of the suit, court will say that a declaration is must. Without that declaration, he cannot take possession from me. Suppose today, my lord, this suit is decreed. Is it not, will not be the duty of the court to decide my title? Am I clear to you? Because I have a deed, you have the knowledge with you. By virtue of that deed, I am in possession and I am the owner. You are asking for repossession to you. While doing that, while decreeing the suit, whether the court is not required to decide the question of my title.
Give me a second.
So खाता खाता ছাড়া কফি নেই ওই জন্য তো আসা
Yes, then
And now kindly come to the impugned order. Not to create the entirety. Kindly come to second page. It transpires, last paragraph. Is transferred from the it transferred from the plain that the instant suit is for recovery of possession and no declaration of title has been sought for by the plaintiff. Also, as per the amendments made in paragraph 13 of the plaintiff is clearly stated that he is not seeking relief of declaration of title over the suit property and are only seeking the recovery of possession of the suit property from the trespasser. Under such circumstances, there does not appear any mandate on the plaintiff to pay court fees as per the valuation of the suit property. Within the status of clear that the court fees are to be paid as per the value of the relief sought for by the plaintiff. Therefore, the valuation made by the plaintiff is correct. But he has not considered whether to grant relief. The title deeds which are on record, by virtue of which I am in possession, having the title, a person will be directed to give back possession to me, ultimately should succeed without considering my title, my deed. According to my humble answer would be that it requires an adjudication.
very good.
And I am relying on judgment for your consideration. One is 1997, Calcutta 202. আমারটা কি মার্ক করা
I will ignore that. Give it to me. You don't have any extra copy?
এই আবার কত চলে
আপনার পাশ দিয়ে পাশে রেখেছি তো সিগন্যাল আছে কি খাওয়াবে কি করে ইউজ করবেন
Yes.
Paragraph 5. Then I will not travel you not the entire paragraph 5. Then paragraph 11.
Yes.
12. 13, 14 and 18. And then এটা দে তোমার সেটা বলবি ওরে পার্থ সাড়ে তিনটে তো বলছি
Yes.
And my lord, another judgment, my lord, 2013, two Calcutta High Court notes, 481. My lord, have you ever seen? Arguing counsel is junior and the senior is assisting.
Benevolence of the senior.
I took assistance.
2013?
Calcutta High Court notes, 481.
Because of the SD police.
SD police. For senior citizen is required. अरे हो गया senior citizen नौ हो
Para?
Paragraph A. Kindly turn the page. It is quoted from another judgment. It's indication 8, paragraph 14. In my opinion, this is the previous judgment relied upon. And here, my lord, I have 1997 also relied upon by Justice Sen.
Hmm.
And the main part will be can you turn over the page? Kindly don't mind, my lord. Can you turn over the page and come to one paragraph starts with the court fee payable. This is the finding of the court. Paragraph number name. This is the problem. The court fee payable will be determined on the nature of the suit as framed in the choice of the plaintiff, provided it is legally open to him to frame the suit in that manner. That is the inquiry. If a suit for declaration and possession, if declaration is the main relief and relief of possession is the only consequence, the suit would fall under 71C of the Court Fees Act and not otherwise. In the present case, the plaintiff are not in possession of the suit property for which the relief of injunction is being sought for. Therefore, it cannot be said that the suit for declaration is not required to be claimed in this case. By clever drafting, you cannot avoid this.
আপনার ইগেন্সটের জায়গাটি তো দাগ দিয়েছে দিলে কোপ ছেড়ে দাও মানে টিকটিকে যায় বন্ধ করে
দুনিয়া কোথায় গেল?
দুনিয়া সব চলে গেছে
The only point, my lord, I repeat, the whether is required and inquiry. Because my title, you have to touch for giving possession. If the suit is decreed, you have to give possession to him. But I am in possession. Whether my title is required to be touched by the court or not, that's the inquiry. You have avoided that. But well, the court can give relief without adjudicating that. That's the precise question according to my humble submission. That's to be.
Yes, Mr. Rai.
Yes.
প্লেন মিস হয়ে যাবে তাদের সাথে শেষ কর ফ্লাইট মিস হয়ে যাবে কোথায় যাবে
Now, if your lordship can consider what is the play, because every inquiry based on the fact matter, the judgment which my learned senior friends also placed, based upon the plain couched. Markali, I am drawing lordship attention, so the plain question.
Page 14.
Yes, it starts on page 14, my lord, you go over the same, and turn to page 16.
Yes, sir.
2 III, my lord, got it?
Yes. Roman 3.
Romans. Litigations going on after that. I turn to paragraph 10, page 18. The different number 38 to 40. Resume the illegal and repeatedly attempted to occupy the suit land and finally on circumstances given under the leadership of different number 38 and 39. Others forcefully entered into front portion of the said land plaintiff of his other corners, which was bounded by Paka boundary wall constructed by the plaintiff and other corners. And entering thereupon the different number 38 to 40 constructed boundary wall on the part of the land which was left vacant by the plaintiff and his other corners, as the said part has already been acquired by the National Highway Authority of India. And since the defendants illegally occupied the entrance of the land of the owners, the plaintiffs and the owners were able to enter into their own land, taking advantage of which 38 gradually took possession of the land of the plaintiff of the owners and ultimately successful plaintiff and the other owners dispersed from their inherited property. And after entering into the suit property, the defendant of 3840 also has constructed a small paka corrugated shield. So this is my cause of action for filing of the suit. Paragraph 11, my learned senior friend also placed. Can you turn to paragraph 12? That the defendants have no right, title, interest of the said land, and the defendants have illegally occupied and in an unauthorized way constructed the boundary wall in front of the plaintiff. A small paka corrugated sits as such. The defendants are mere trespasser in respect of the suit property. The defendants at present occupying the suit property as in different occasions given 38 to 40 are showing the suit land to the different intending purchaser and now trying to sell the suit property. So my assertion is that it is my plate. I have to prove incidental title and possession. Now the defendant, if they raise any document on the basis of which it
No, you have skipped paragraph 11.
yes, that is placed. The certain deeds cannot considered. What my learned senior friend says, X property belongs to Y. X executed some deeds in favor of Z. I am not pointing to the documents, neither the owners nor my predecessors.
Where is the amendment to that effect?
Yes. That is why Malakali can turn to that portion that there are different of 3840 man got it. Paragraph 10.
What is the source of your title according to your plan?
Yes. That is
United.
right.
Now paragraph 11, in the meantime, the plaintiff learned have executed 5 deeds in favor of the defendants.
Who Malakali 1 to 37. Defendant number 1 to 37. Who are the defendants? What title they have of the property?
You are not a party to that deed.
So it is a property belongs to, according to the plain case, property belongs to Y. X executed some deed in favor of Z. Whether I am bound to, I have to prove my title. According to me, the title is clear so far B is concerned. Now, if they want to clouded that title, the judgment which was read out from there, I will satisfy your lordship. What normal court has said. After that, may I read? The defendant present occupying the suit property as in different occasions such as such. So the suit property that the plaintiff is one of the owners of the suit property and has filed the suit for protection of his right and also for the protection of the rights of his other owners, being the eldest in the family. And declaration of title in respect of the suit property is not necessary as the defendants. Here, I have categorically mentioned the defendants. Paragraph 13, your lordship will find.
Very good, sir. Then where is the application?
Yes.
Which has been rejected?
Page 45. And turn to page 47. Page 47. Paragraph 4. Subject to question order, this is the sum and substance of their objection.
Very good. Any other points, sir?
Now, my lord, can you consider the impugned order which is subject matter adjudication? My lord has gone through it. My lord, I am not repeating the same. So, as of this day, the plate has couched. I am the owner of the property by your inheritance. My father was the owner. I am the owner. The defendants, my lord, can you consider defendants have no right and interest. I am telling they are the trespasser. Now, my lord, what will be the effect of the deed? And how my suit will be adjudicated under what provision? And this is, if your logically takes up the Court Fees Act 1 subject to. My lord has gone through it number of times. My lord.
No, even then. Every time new points come up.
Can you consider section 7?
Yes, sir.
Section 7, 6. A. That was in a suit for recovery of possession of immovable property from a trespasser who has no declaration of title or to the property is either paid for or not necessary for disposal of the suit, according to the amount which the relief sought is valued. What is followed by the lordship? The relief sought has been valued. So whether it contemplates the valuation of the subject matter or the subject matter of the suit, this is the my learned reference is also distinguished in this fashion. It is the suit should be valued or the court fees.
Suit value has to be accepted.
Suit value should normally be accepted.
Not the value of the deeds.
I'll satisfy your lordship on this aspect also. Now, my lord, can you pause there for a moment? This squarely came out for consideration before this Honorable Court also judging the authority. I mean, 2015, SSC online. 2016, 159, all India cases, page 680.
Authored by
Justice Jyotiba Bhattacharya, sitting with Manor Justice David Sharkey.
Din.
Manor, can you consider paragraph 5? Because that is the main thing. But the defendant contends the suit by filing a written statement, stating that plaintiff had no cause of action for filing of the present suit. The parties laid their evidences to the claims of the suit. The learned trial court, after considering the pleadings of the parties and after evidence was placed to dismiss the suit, remained on the ground that the relief claim in the suit has not been properly valued and the advertisement fees has not been paid in light of the provision of contained in section 75B of the West Bengal Court fees. The learned trial judge also held the allegation regarding disposition of the plaintiff from the suit premises by the defendant has not been corroborated by any independent witness. Thus, the suit was dismissed. Apropos to this, Manor, can you turn to paragraph 10 and 11? 8 to 11. Let us now consider the part of the submission of Mr. Bhattacharya in the light of the provision contained in section 7(4)(a) of the West Bengal Court Fees Act, which runs as follows. I am not reading the same, my lord. 9. Which does make it clear that if possession from a trespasser is sought to be recovered on the basis of declaration of title of the plaintiff, then the plaintiff is required to value the suit on the basis of the actual market price of the suit property, and is also required to pay advertisement court fees or the valuation of the suit property. The said provision thus make it clear that if the plaintiff files the suit for recovery of possession of trespasser without seeking any declaration of his title in this property, or in a case where the grant of relief paid for by the plaintiff is not dependent upon declaration of his title in the suit, then plaintiff is not required to value the suit on the basis of the actual market price of the suit property. So it can be valued the suit on the basis of the valuation of the relief claimed in the suit. Thus, if we apply this test in the present case, when we find that since the plaintiff has filed a suit for recovery of possession of trespasser without seeking any declaration of his title in the suit property, and further since grant of such relief to the plaintiff is not dependent upon declaration about his title in the suit property, he can maintain a suit by following the relief claim in the suit as per his own choice. That be the position, we have no hesitation to hold that the suit has been properly valued and sufficient court fees has been paid by the plaintiff in the suit. Pause there for a moment. It is the case the defendant is made out there armed with certain documents. We have said that certain deeds have been executed.
So in a suit for recovery of possession, you have not sought for declaration of your title. Rather, you have sought for declaration for avoiding those deeds.
Yes.
So according to you, this judgment will the guiding factor.
Yes, and considering the same, the next only this is 2019 Calcutta, yeah, 2000 page 63.
Paragraph, is there any paragraph?
Yes, it's my lord. I'm drawing only your attention to paragraph. The judgment internal page 1, 2, 3, 4 page at the bottom left hand side bottom corner. You should find the page numbers are there.
Yes, I got it.
2010 volume 12 SCC, my lord, got it. Yes. Sardul Singh, what is followed from my lordship? That is the principle. Non-party to certain deeds paid in in which a non-party certainty is paid earlier, that the same be declared null and void. It was held that the court fees payable were according to the valuation of the relief by the plaintiff in his plaint. Where the executor of a deed wants it to be annulled, he has to seek cancellation of the deed. But if non-executor seeks annulment of the deed, he has to seek declaration that the deed is invalid or or illegal or not binding upon him. So the plaintiff in reported case, being the non-party to the deed, only had to seek declaration that the deed is not binding upon him, and not a cancellation of deed as such a court fees computable own valuation relieved by the plaintiff.
In this judgment, several charts have been made where court fees are to be made, where court fees are to be
Punjab court fees, Bala, this judgment concerning the Punjab court fees, and it was on the contrary, it was came up with the Honorable Apex Court. Now, my lord, kindly consider the next page. Hence, the crux of the cited judgments. My lord, you'll find next that the courts already do not interfere with the own valuation of the suit by the plaintiff. In a suit under 74B 1970 Act, however, in the gap of the suit, the plaintiff seeks cancellation of a deed or seeks a relief which requires higher valuation. The court has to look into the objective standard disclosed in the plaint for assessing the valuation. And in absence of disclosure of such objective standard, the court may undertake an inquiry under section 11 to ascertain the proper court fees. If we examine the plaint filed by the plaintiff, the above light, it seems that the same seeks a relief of declaration consequential is simpliciter, and not cancellation of any deed or any other deed necessitated higher valuation. Since the plaintiff opposite party was a third party to the deed in question, the suit for declaration that the B schedule described instruments were all vague, illegal, and fraudulent, and collusive instruments, and both were void administratively governed by the 4B of the 1970 Act. We did not tantamount to seek cancellation of deed in question, as such the plaintiff was entitled to attribute his own.
That I am saying.
That is so called, my lord. That is. Now, my lord, if you logically consider that, and it was ultimately held that if you want for declaration, because my lord,
Mr. Basu's contention is that in the
They have-
garb of seeking that declaration, you have practically sought for declaration of your own title, which is creating a cloud of the to the title of the defendants.
I bow down to your lordship. That answer I am
My
given.
question is a little prior to that, whether this inquiry is required or not.
Very good.
And now, my lord,
This law is settled that I am not a party to the deed. I need not.
If your lordship can takes up the judgment which my largest senior friend referred, that is 1997 volume 2 CWN 152. Can you consider paragraph 2?
Yes.
The aforesaid title suit was filed by the petitioner against the opposite party for recovery of possession of the A scheduled property of the plaintiff, alleging inter alia that the petitioners purchased the property and was constructed and renovated a cinema hall by spending more than 4 lakhs rupees. When the opposite party disposes the petitioner from the suit property by falsely claiming title thereto on the basis of certain deeds of release executed by the petitioner in favor of the opposite party. This is the interstate dispute between the parties where one party is claiming that you have executed the deed. So whether he executed or not, being executed, he has to ask for cancellation.
So here the prayer for declaration has been made.
That is why I said you cannot make that such declaration, because document which is apparent on the basis of which the parties are claiming title over the property are executed between the parties.
No, Mr. Rai, what do you want to say about that?
What my understanding friend is saying, here the declaration is sought for. The court says no, you have to go for the
But in your case, you have not sought for any declaration.
declaration. Apart from this, here my lord, from the
You have not sought for declaration of your title.
and that is a 75A will come into operation. Here, my lord, why I distinguish this judgment, which is clear on Mr. Basu, is that here a document is trying to avoid by the parties who are the executant of that document.
Naturally, they want for a cancellation.
There, my lord, the cancellation not been paid for. That is why.
Subject matter of this
Yes,
concern
my
of
lord,
that.
if you logically consider. Yes. Paragraph 14, if your lordship can consider paragraph 14. It is therefore clear the manner in which the relief is sought and the cause in the plaint shall not be sole criteria of determination of court fee. The court fee shall not operate bar for the revision or valuation of the court in the basis of valuation provided in the plaint itself. Now, my lord, kindly consider paragraph 17. The petitioner plaintiff being admittedly out of position, her title deed being admittedly in possession of the defendant opposite party. She having admittedly executed some deeds of release in favor of the opposite party. Even though it is alleged to be not in respect of suit property, a cloud is unquestionably casted upon the title of the plaintiff in the suit property. The release for recorded position and permanent mandatory injunction as paid for in the suit cannot be granted unless the said cloud over the title plaintiff is removed. The cloud has become deeper still because, as submitted by Mr. Manager, defendant is interested to deny the title of the plaintiff on the ground that she merely a name lender or in
So she was an executing to the deed. So here lies the distinction.
Yes.
Any other point?
These are the points my lord, probably my lord. I'm not dispute about that. At the outset I submitted the executant has to. But here probably up till now not a single judgment, my lord, touched the point I want to canvass before my lord. In a 7.5, 7a, language, can you see the language? 1 second, can you read that?
7.6a.
Can you see the language? Or disjunctive.
Or necessary for disposal of the suit.
What? This is not my case. This is not the defense case. Plaintiff himself said. Plaintiff himself said in his plaint that the property has been transferred. The property which they are claiming, my lord, possession has been transferred by a deed, by deeds. Whether for the purpose of giving repossession to him, whether those deeds are required to be considered by the court or not. Here, a simple case, plaintiff has not prayed for. Plaintiff has not prayed for. Whether this is the product of a cunning drafting. This is the precise point I want to canvass before. Plain reading of the plaint clearly suggests there is no declaration. So the point which my lord learned friend has submitted, my lord, has to be accepted because he is not the party to the deed. But the relief which has been claimed for the purpose of decreeing the suit, whether the court is required to adjudicate
The title.
the title by which he is claiming repossession. And that's why, my lord, or inquiry of the court. First party is he declared. Whatever he declared is sacrosanct. With Bhakta.
In a suit for recovery of poison of immunity from a trespasser, where no declaration of title to property is
moment, if his case is
no.
what is the
Or
meaning of
necessary
or?
for disposal of the suit.
Whether necessary for disposal of the suit, that court has to inquire. I want that stage. Court has said that not inquired, not necessary. Well, can you visualize? Today I am in possession by virtue of a title. I am in possession.
So according to you, Mr. Basu, for adjudication of the suit,
What is the suit for? Repossession.
for adjudication of the suit for recovery of possession of immovable property from a trespasser, the
If
court
it
has
is
to
required.
arrive at a conclusion whether declaration to title to property is required to be adjudicated for the purpose of disposal of the suit.
In a case where plaintiff himself pleaded that property has been transferred to somebody else, who is in possession now.
Wait.
And he claims that he tried to avoid that. But we humility submit, my lord. The judgment which has been cited by that, but
Very good. So I shall
has not
consider.
been considered.
I shall consider.
I'm grateful to my lord.
Asu.
Out of
Hearing
the
is
right time,
concluded. Hearing is concluded. Judgment is reserved.
we are in right time. Well, try this way. কোথায় কি করে? এটাই হবে আবার। হয়, another matter is there. এখানে করতে হবে কালকে। কালকে আমি চলবো। জেনে দেবে কেন? হ্যাঁ? মানে
London DSG is saying that above-age person should not be allowed here. But kindly pass the direction not to enter into the courtroom here.
এই বইটা যাবে বাবা রে। This book belongs to whom?
Is yes, sir.
It can be.
Yes, yes.
Last time he came, he had a work to it. We don't know what is going to happen.
That's why today I will go side by side. with
No,
Mr.
he brings rain. Now he
Okay.
brings rain.
He thinks that nobody is with me. Honorable Judge is saying, remember this. I am always with you, sir.
Even I am with you.
Everyone is. I am grateful to my. Grateful to your lordship. কত নম্বর ছিল? মানে 70 মানে tally adjourn for that day. I think for this circuit. মানে এই report ইয়ে করে না।
Item number 70.
Well, item number 70, my lord, I appear on behalf of the petitioner, my lord.
63 স্যার যন্ত্র থেকে বেরিয়ে আসুন বাম চললাম বেরিয়ে
My lord,
বেরিয়ে
the difficulty is, my lord, Mr. Basu.
Mr. Basu is seeking an adjournment.
same table he cannot.
Very well, my lord, kindly give him adjournment, kindly extend my interim order till the next circuit.
Very good.
Yes, yes, can you do it?
Mr. Basu appearing for?
I am for the opposite
My lord,
party.
I'm for the petitioner, my lord.
On behalf of the opposite party, Mr. Basu, learned senior advocate, seeks an accommodation and requests this court to pass an order for placing the matter before the next available circuit bench. Stop para. Mr. Ghosh, learned advocate, appearing on behalf of the petitioner in virtual mode.
কোথায় বসে আছিস রে?
Submits
ও বাবা।
submits before this court that the interim order as passed earlier may be extended. Stop. In view of such submission, let the matter be listed before the next available circuit bench under the same heading. Stop para. The interim order. Mr. Ghosh, when the interim order is expiring, sir?
Your lordship can see on 19th of February 2025, Rai Chotto was the granted interim order till 31st of April. Therefore, the matter did not appear before.
Order as passed earlier is extended till the last day of December 2025 or till further order, whichever is earlier.
Grateful.
I'm grateful. And my lord, one thing, my lord, I should submit, my lord, I waited for this matter to be taken up by my lord. But Mr. Basu will not allow me to do the matter before your lord.
Yes, yes, my friend, same day enrollment. Same day enrollment.
Last day of November.
I am grateful to your lordship. my lord.
December. Yes.
63, না, ওটা 70 হলো। 63 টা তো। 70
Mr. Ghosh, তুমি কোথায় বসে আছো?
মাঝখানে ওটা তো জাম পড়ে গেছে 70 টা আপনি করুন। 63 হয় নেক্সট ওটা 62 হয়েছে। Call 63. 62 will go to chamber.
Yes, I'm for the opposite party.
Who is for the petitioner, sir?
The last option, Mr. Devanjan Das. Can you Mr. Newton the chaplain? Your lordship, can you record this that matter? Where a suit was filed that was subsequently dismissed for default. They filed the plaintiff filed a.
Where is Mr. Das? Both the Das are not present. Dases. Das and Das. None appears on behalf of the revisionists. For ends of justice, this court is not inclined to pass any adverse order today. Let the matter be listed before the next available circuit bench under the same heading.
শোনো
একটু ওনাদের ডাকুন তুমি 2 মিনিটের জন্য নাম
করবে করবে লর্ডশিপ
ওই কিছু না তো নাম্বার একা একা করবো সবার না গাড়ি করতে দেবর্ষিকে তো দেওয়া যাবে না দেবর্ষিকে দিলে পরে এক প্যাকেট দিতে হবে দেবর্ষিকার
Emol is ধর প্রপোজালটা খারাপ দিয়েছিলাম আমার প্রপোজাল শুনে সব পাঠিয়ে গেছে বলে বাবা তো প্রধান হবে না আমি প্রপোজাল দিয়েছিলাম মাংস ভাত ফ্যামিলি আমার আমার প্রপোজাল শুনে বেটি ঠিক আছে
মানে মাংস ভাতের আয়োজন চলছে
মাংস ভাতের
স্পেশাল মাংস ভাত আসছে ওটার জন্য দেরি হচ্ছে
ওই মমিনুল কোথায় ওই ওর জন্য ইয়াকের শুট কি করে দেবো আমরা ইয়াকের শুট কি ইয়াকের শুট এটা কি
Sorry, still.
On the earlier occasion, actually, I was directed to hand over the copy, in spite of. Obligation paid to me. Vision.
তুমি কি WPA 3275 এর অর্ডারটা অ্যানেক্স করেছো এই অর্ডারটা রিটের
বলছি
আচ্ছা হিরণ পেয়েছি পেয়েছি
35
পেয়ে গেছি
Lordship, yes, to that extent, actually, I am pointing that. Lordship, actually, license always should not be granted by way of documentation. It may be acted, it may be granted upon the act of the parties. This is my plea, that I am being, staying in that place last 50 years by generation. And that we are bona fide occupier of that property, and we have such documents, and we have got so-called notice from the authority concerned. Only notice thereafter, on 10th February 2020, the petitioner was directed to appear before the concerned authority, responding number 4, but it could not understood the content of the notice because they all are unable. He has not appeared. Even along with him, there are so many people like this.
Status in respect of the property where from you have been.
Loss of license. Nothing more than.
How to prove your rights?
Lordship,
How to prove? Because the transport, for the estate officer, how to prove your rights?
Lordship, we.
Simply because you have occupied it because then license.
Lordship, there, we, staying there, we constructed, temporary construction we made there by virtue of the act of the petitioner. They have not objected, that the authority concerned never objected, and so many people are, no, not, there's so many people are deciding over there. Actually, it is a matter of, there are several schemes made by the respondent officers in several parts by making settlement arrangement schemes. That's why we are seeking the protection of law, that, and in that matter, where we have document of our possession, our electricity, and everything, and whatever the contention of the authority concerned against whom I am here. They also, I do not got the chance to follow the documents which they have relied on. That is why I am here. That I am looking.
December 2024.
Same.
Okay.
Mr. Mojumdar,
Lordship.
we,
All the one almost
Yes.
non-functional.
It is now better situation.
Now only four.
Yes. Yes.
Your court number 4 is after the recess is taken up.
That is why more matter is also taking. That is why more matter is also taking. That. Yes, sir. Grateful, Lordship.
I did not physics.
Well, the petitioner has come with a very innocuous prayer.
for expedite hearing.
No, my lord, actually, there was an execution petition of the arbitral level that was filed before the Honorable Learned District Judge Darling. Now, the first execution petition, just Learned District Judge said, I am granting you liberty to file another application, but it is pending since long. Recovery of the arbitral amount to some extent was made. Liberty was given to the petitioner to file a fresh execution application. First execution application was disposed of. During the second execution application, subsequent.
It is an execution of the award.
Second, subsequent presiding officer of that court was of the opinion that this matter should go before the commercial court. In vain, the petitioner tried to persuade the judge that this is a matter which came up before the court prior to the commencement of commercial act. Order was passed. Petitioner thought it fit either this court or that court. I need to get my money, so he was waiting for the papers to be given to him, my lord. Only the execution petitioner was listened by the petitioner, and the original award without which no petition can be maintained for execution of an award could not be traced in the district judge. Petition after petition was filed before the judge, praying before that court. Your Honor, may we please have to send the file to the learned court of the learned commercial judge.
Transfer of degree.
Only this much. Same district, he could have done it. My lord, of the record act, and I was there in that trial. Very surprisingly, the learned judge said, "Could I get down from a chair and search out the record for you?" I was personally presented. And because I cannot bring it on record, I switched off the memo. And it remains there. Our prayer now before your lordship is, your lordship is kind enough to direct that court to transmit the records to the commercial. And
What is the affidavit of service?
it was filed long back around.
No. After 22/8/2024, service has not been affected. That is the last order.
Now we served them, my lord.
The affidavit of service is required to be ready. একবার দেখান।
Kind of digital Wednesday will come with the service and my lord can dispose of the matter. Because it is only a question of transferring the file.
Very good.
Get me.
Let the, as per request made on behalf of the petitioner, let the matter be listed on August 20, 2025 under the same heading. Day after tomorrow.
Yes. The next. There are 57.
Seven, my lord, we have not received the copy of affidavit in opposition. They had filed it in the court. That is my instruction.
What do you want?
Because we have not received the copy of the affidavit in opposition, filed by them, filed by the opposition.
দেখি দাও ফাইল দিন এফিডেভিট অপোজিশন পাইনি বলছি ফাইল করেছে কি?
Yes, ma'am, it has been recorded. Your-
You are for the petitioner.
For the petition.
Oh. Who is your other side, sir? Mr. Kalipodas, respondent number 1 to 3.
Yes, ma'am.
At the time of hearing, what's your good name?
Mayank Nari. Mayank.
Mayank.
Yes.
You are appealing.
No, my lord.
Take your seat for some time. The parties are not represented. Stop para. For ends of justice, this court is not inclined to pass any adverse order today. Let the matter be listed on August 20, 2025 under the heading for dismissal. এটা কাল থেকে দেখিয়ে দেবেন। Next. Somebody is appearing.
Yes, but I appeal from the defendant petitioner. I was the virtual mode.
In which mode, sir? Which
Audible, my lord. Item 69.
Oh, I see.
69.
69 has not yet been called, sir. Mr. Bhattacharya, it has been not been called. It will be called.
Oh, just now 68 has been completed. Oh, yes.
Sanjay Kumar Dalmia, Mr. Bhattacharya.
Indeed, your
Yes. Sanjay Kumar Dalmia.
He's leading you.
Indeed.
Yes. But defendant is the petitioner before Lordship, my lord.
You are not ready.
But the last occasion they paid for I obtained an interim order that was first on 13th August 2024. Thereafter on 10th September 2024. So that has been expired also, my lord.
Very good. Day after tomorrow, Mr. Bhattacharya?
Yes, madam, that is, well, that, yes,
He's
yes,
always in
I have no
difficulty.
problem. Oh, yes.
On behalf of you are for
It
the
is
opposite
difficult.
party, no? On behalf of the opposite party, an accommodation has been paid for. So in view of such, let the matter be listed on August 20, 2025 under the same heading, preferably at the top of the list.
Yes, I'll get through. I'll get through.
Day after tomorrow.
Yes, sir.
Yes, call the next matter. Not today. The parties are not represented. For ends of justice, this court is not. For ends of justice, this court is not inclined to pass any adverse order today. Let the matter be listed on August 20, 2025 under the heading for dismissal. আর কিছু আছে?
Second appeal, my lord, it was filed in principal bench, later transferred to circuit bench, Jalpaiguri. Because I was confused about the interpretation, because I have inquired as your lordship in the detail. Can it be included in the not part of the election? Well, not a password matter, that's it.
Password matter.
My lord, item number 57 password. My lord, can please to fix some Wednesday or Thursday.
You is your other side.
No, this is the motion. 50.
Motion I can take up now. So far as second appeal is concerned,
I know. Seven suppressed. And
wait, sir. Not two at a time. What is the matter about?
2007. Thereafter, the petitioner lost interest upon the matter. We asked for the respondent, and as soon as I came to know that the applicant has died, we took out an application, can 1 of 2024, and it is not responsible.
What is the can one?
So that is an application for where we have stated that the applicant petitioner is already expired. Before 7 years, statutory period also was no substitution.
So happy habits. Who is your other side?
I am inquired, but I could not find anyone. They are not at all interested for petitioner appeal.
No, any conducting advocate was there.
No, because principal bench also they did not appear. But as the subject matter land is under the jurisdiction of.
Give this slip, it will appear tomorrow. In which matter, sir?
72. Last.
72 have passed an order. You are for the petitioner. Who is your other side?
But service of notice was directed have served all the services done except one.
কি আছে দিন 72 একবার বলছেন দিন পাসওয়ার্ড হয়নি হবে ওয়েট করুন একটু তোরা বল कीजिए 72 में आ गया
But respondent number 11 could not be served. The postal tracking report mentions addressee cannot be located. Addressee moved, return to sender.
give the affidavit, file the affidavit of service.
Yes. But the online postal tracking is not available because of the post office glitches. But I have filed the envelopes wherein it has been refused by some of the parties.
And with regard to the others,
Others that is already served.
postal tag reports are there.
Those are.
Let me see.
Only in respect of the respondent number 4, the opposite party number 4, it could not be served. Well, this is the same suit, my lord.
Give me a second, sir. What is the matter about?
My lord, this is the
Which order is under challenge?
This is ordered in circuit suit number 44 of 2008. The entombed order is annexed to the loss of the.
Order number 139.
Similar order was passed, but a similar order was passed by the learned trial court in this very suit in respect of the plaintiffs and the defendant.
What is the nature of the order?
But in an application under order 23 rule 3, the injunction order has been relaxed and the plaintiffs have been permitted to execute a deed in favor of the defendant number 9. Relying on a previous order passed by the same trial court. That previous order is already been set aside by this honorable court. Order number 122 it reflects in.
Sir, give me a second, sir.
Lordship.
What is the petition on order 23 rule 3?
It's a joint petition filed by the plaintiffs. 3 plaintiffs are there. Filed by the 3 plaintiffs along with the defendant number 9. It's a joint application. But I am enclosed.
Who are you then?
I am the defendant number 6 in the same suit.
You are not a party to the compromise.
No, I am not a party to the compromise. Malad takes up the petition. I have also annexed the petition. Malad, at page number 34 of my application.
Then what is the suit for?
The suit is for declaration, cancellation of deeds, and recovery of possession and other consequences. But I will enclose the plaint also. Malad takes up page number 23, Malad. And the prayer portion. Paragraph 16 ABC. D.
Degree declaring sale deed numbers eto executed by mother of the eto in favor of the eto are voidable, and so in the event all the defendants do not sound high, how a compromise deed can be passed?
That is why, my lord, a similar order was passed by this trial court, which has been set aside by the honorable bench of this honorable court, my lord, on a previous occasion in another similar provisional application. And this is the order passed by honorable justice Sabyasachi Bhattacharya. There is the order number 122, which was passed in similar terms, which has been set aside. Relying on that order number 22, my lord, 122, this particular order number 139 has been passed by the learned trial court. Therein, my lord, the application was made by the plaintiffs, 3 plaintiffs, and the defendant number 5. Jointly, under order 23-2. No application under order 39 rule 4 has been filed by any of the parties.
Take your seat for some time. So what is your contention? That you are the before the trial court, you are
Defendant number 6. I am the defendant number 6 in the before the trial.
you are not party to the compromise.
I am not party to the compromise. Yeah, what the plaintiff did, these three plaintiffs first effected a compromise between between themselves and the defendant number 5 by filing a petition under order 23 rule 3 seeking part decree. But that petition was rejected by the trial court. However, the trial court passed an order permitting the three plaintiffs to execute a deed in respect of part of the suit land in favor of the defendant number 5. I challenge that order before this honorable court. This honorable court, taking into consideration of the matter, has set aside the order of the passed by the said trial court, stating that in an application under order 23 rule 3, the order injunction order cannot be relaxed. More so when there is no application under order 39 rule 4 made by any of the parties praying for relaxation of the order of injunction. So
now what happened?
So relying on that, the trial court's order, the previous order which was passed, already challenged before this honorable court, the learned trial court passed another order. This is the order under challenge. This is the compromise petition which was filed jointly by the plaintiffs and the defendant number 9 in a similar fashion.
Without invoking
order 39 rule 4, just by filing a petition under order 23 rule 3.
And without impleading the other defendants.
Without impleading the other defendants, without even impleading the other defendants, it was filed only by the three plaintiffs and the defendant number 9. And in that application was subsequently allowed. Challenging that application, I have.
Then if the order 23 is allowed, what is rule 3 then?
Order 23 is compromise between the parties.
দেখি একবার দেখি তো একটু সিপিসিটা পাচ্ছ না? Ashwin. The affidavit of service as filed today on behalf of the petitioner / defendant number 6
Yes.
is taken on record. The subject matter of challenge in the instant revisional application. Acha, none appears on behalf of the opposite parties despite service.
The dependent number, respondent number 4, it has returned answered with addressee cannot be located.
Very good. The subject matter of the instant revisional application is the order number 139 dated 12/12/2024 as passed in title suit number 44 of 2008 by the learned civil judge senior division Jalpaiguri, whereby and whereunder the said court allowed a compromise application as filed by the plaintiffs and the defendant number 9.
The court rejected the compromise, but proceeded to give other reliefs which was not even prayed for.
Stop brother. কি লিখলাম?
The supplementary of the instant revisional application is the order number 139 dated 12/12/2024 as passed in title suit number 44 of 2008 and by the learned civil judge senior division Jalpaiguri, whereby and whereunder the said court allow the compromise application as filed by the plaintiff on the examination.
এটা বন্ধ আছে? বন্ধ করুন।
I'm giving the right number.
No, Lordship. Lordship is on Wednesday, Lordship. Wednesday.